Welcome to our Spring O'Connor chair. We were really hoping that we'd be able to be in person tonight, but the weather just didn't want to cooperate. So rather than postpone this event, we decided to move it to our virtual stage. And we want to thank you all so very much for joining us. I would like to express our deep gratitude to the A. Lindsay and Olive B. O'Connor Foundation. It's through the generosity of the O'Connor Foundation that this evening's event is possible, and we are deeply grateful. I would also like to take just a minute to recognize some folks who are with us tonight. Miss Amy Warner, Director of the A. Lindsay and Olive B. O'Connor Foundation, Dr. Laurel Bongiorno, Vice President of Academic Affairs and Dean of Faculty, Dr. James Kellerhouse, Vice President for Institutional Advancement, Karen McGrath, Senior Vice President of Enrollment Management and Student Experience, Sharon Dettenreiter, Professor Emeritus, former Department of Nursing Chair and Nursing Program alum. Distinguished guests, faculty chairs, faculty, staff, and students. And finally, I'd like to thank Nursing's Events and Community Committee so very, very much for not only putting this wonderful event together, but also for flexing so very quickly to move it to a virtual format. A special thank you to John Janetz, who made this switch so seamless. You are a rock star. Professor Kathleen Ash is chair of our Events Community Committee and is serving as our moderator this evening. Kathleen Ash graduated from Russell Sage College, where she earned a Bachelor of Science degree in nursing. Soon after graduating, Kathleen joined the Birthing Center at Bassett Medical Center in Cooperstown, where she applied and developed her knowledge and skill in the care of women and children and families. In 1994, she earned a Master of Science degree in nursing as a clinical nurse specialist with a concentration in parent-child nursing from the Sage Graduate School. While at Bassett, Kathleen served in the capacity of a staff nurse and as a clinical nurse specialist. She collaborated in the creation and launch of a new obstetric operating room with an implemented electronic medical record system, ensured nursing practices were evidence-based, educated nursing staff on clinical practice, and coordinated care with inpatient and outpatient services. After serving as an adjunct clinical professor in obstetrics for Hartwick College for 11 years, in 2019, Kathleen joined the Hartwick College Department of Nursing full-time as a clinical assistant professor of nursing. Her nursing expertise is in women's and children's health and rural health. Her interests lie in women's health issues, care of newborns, and healthcare in rural populations. She's a member of the Association of Women's Health, Obstetrics, and Neonatal Nursing and Sigma Theta Tau. She's an outstanding educator and a colleague. Please join me in welcoming Professor Kathleen Ash.
Good evening. Thank you for that kind introduction, Dr. Grust, and welcome to our Spring O'Connor chair. Spring is kind of a funny word to use tonight, given our weather conditions. I also want to thank our swift transition to Zoom, and I'm grateful for Zoom because we are still able to carry on with our presentation to all of you this evening. Before I introduce our panelists for this evening, I want to give you a couple reminders. I'd like you to keep your cameras off and your mics muted. And I'm also going to ask you to shut your cell phones off. You may be saying, what? What did Professor Ash just say? Shut my cell phone off? I haven't done that since I got the thing. But what I'm asking you is to devote the next hour and a half of your life to listening to what our panelists have to tell you about. Tonight's topic, safety in nursing and legal issues. These are really important topics. This isn't just a fun facts kind of O'Connor chair. This is information that's going to impact your career. Our panelists are accomplished experts in their fields, and we are fortunate to have them this evening. So please give them your full attention. At the end of both of their presentations, we're going to have a time for Q&A. So I welcome you to put your questions in the Q&A at any time during the evening, and we'll get to those at the end. So I'm now going to introduce our first panelist, and that is Paula Moshier. Paula has a Master of Science in Health Administration. She has a Bachelor's of Science in Nursing. She's a registered nurse. She's a certified medical practice executive. She's certified in professional and health care risk management. She's a vice president of Quality and Patient Experience for Bassett Healthcare Network. Ms. Moshier was a valedictorian graduate of her class at St. Elizabeth's College of Nursing. She completed her Bachelor's of Science in Nursing at Syracuse University. She obtains her Master's in Health Administration from Utica College and plans to graduate from Case Western Reserve University with a doctorate in nursing practice and nursing leadership in May. So 2 months away. Paula's a senior. Congratulations. That's very exciting. She has held leadership roles in a variety of clinical settings, including ICU, perioperative services, cardiology services, patient and staff safety, and risk management. She holds certification in enterprise risk management, medical practice management, lean, and just culture training. I give you Paula Moshier.
Thank you, Professor Ash. I want to thank everyone who is on the call tonight. I know it's getting late on a Friday night, and I am very relieved to know that you are all home or someplace safe instead of on the roads. So thank you for this opportunity. Hartwick holds a warm spot in my heart. I have both a sister who graduated from Hartwick and a niece who graduated from the nursing program there after I recommended that she go there. Personally, I've spent about 10 years in patient safety and risk management, and I would like to share with you what I've learned over those 10 years, just as a general overview. And our next speaker is really going to add on to what I'm telling you, and there's some really important points that will protect you going forward as nurses in your careers, and help you think about how to be safer. So thank you for your time and attention. I'd like to have the next slide, please. So first, we're going to talk about what a safety event is. There's a few types of safety events. There's an actual safety event and a near-miss safety event. So actual safety events happen, we frequently hear about the Swiss cheese model. Safety events occur when the holes in the Swiss cheese line up and things don't go quite right. Our barriers or our defenses all have gaps in them, and there's various ways for this to happen. We can have technical failures, which could be equipment failures. We have human error, which we're all human and we make mistakes even though we wish we didn't. And we have organizational failures, which is sometimes we have policies or procedures that aren't where they need to be to protect patients and to protect us as staff. So sometimes these can occur and are found after the event and are actual events, but did not cause harm. An example of this would be someone who had an allergy, say to an antibiotic. They received the antibiotic and luckily they did not have a reaction. There are also near-miss events where we may have had a patient who had an allergy with a history of anaphylaxis and it was ordered, but as a nurse, we caught it, or as a pharmacist, we caught it. So it didn't actually reach the patient. And that's called a near-miss event. Thank you. Next slide. So why are we talking about this today? Why does it matter? So here on the left side of your screen, this is why I get really energized about talking about patient safety. Medical errors are the third leading cause of death in the United States. Big statement. There's a publication in 2019. I have a little bit of history here on the right-hand side. The father, or what I consider the father of patient safety, was Dr. Lucian Leap. In 2002, so 21 years ago, he made, in a presentation to Congress, he declared that there are about 100,000 fatalities annually due to medical error, but we truly didn't know the number because we're not keeping track. So in 2005, the government created what's called a PSO, or a patient safety organization. And what that does is it allows us to talk about error in a protected review. So our next presenter will talk about that a little bit. There are specific things we have to do so we can talk about patient safety events. and medical error that keep them protected. And what the government felt is, if we can talk about our errors and our events, we can make improvements and prevent future error. So here we are in 2008, 90% of all medical errors were found to be preventable at that time in the study done then. In 2013, 300 near-miss events occur for every actual medical error. So just think about that. The near-miss events, the near-miss safety events are really our opportunity to protect our patients and prevent future harm. These are the gold nuggets. This is what we're after. So in 2017, another study, 50 to 96% of safety events go unreported. And here's 2019, where the estimate has grown from 100,000 fatalities a year to 400,000 deaths annually from medical error, making it the third leading cause of death. Then what's happened since then? Last year, we had the Redonda Vaughn trial, and she was found guilty of reckless homicide. There's a number of points I would love to discuss about that. If we're interested in talking about that in the future, that could be a whole presentation to itself. Next slide, please. So where are we today? Here's a 2023 January publication. 25% of all hospital admissions have an adverse event. That's 1 in 4. Of that, almost 1 in 4 were preventable. Here we get back to near-miss events, and can we intercept error? I think as nurses, we have the greatest opportunity to intervene because we see the patients more than anyone. Most common type of adverse event is an adverse drug event, almost 40%. This is really important information to tuck in your pocket, because when you're passing medications, pay attention. This is where you have the biggest opportunity to protect patients and ultimately to protect yourself, because no one comes to work to make an error. No one comes to work to harm a patient. It still happens. So one of the really important things you want to look for when you're preventing medication events is if you have it available to you using your barcode scanning for medication, barcode scanning hooked to your MAR. It's a double check. Make sure you use it if it's available to you. Also consider when you're administering high-risk medications. Those would be your insulin and your heparin. Safety events associated with nursing care, 15%. These were classified as your, falls and pressure injuries. And I will say I've done a lot of work on falls, patient falls. They're not all preventable. They just are not. Healthcare associated infections are, about 12%. Most important thing there is make sure you wash your hands. That's important for your patients and for you. Next slide, please. So what can we do about this? Now that we have this information, we need data. So we're going to talk about reporting. So this is from one of the articles that I've referenced in this presentation. To improve patient safety, we really need to evaluate the safety events when they occur, how frequently, and what causes them. And this really has to do with analyzing the data. And that means safety event reporting, error reporting, incident reporting. They're all the same thing. We need to acknowledge and talk about our errors. In order to improve them, we need to report. Next page, please. So why does reporting matter? Accurate recording of the event. So it's important that we have the details so that we can prevent the event from happening in the future. Allow for appropriate mitigation. I'll give you an example of this. The Redonda Vaughn case would have been one of these, but I'll speak about one that I'm familiar with, where a patient received a double dose of beta blocker, and it was realized the patient had a double dose of beta blocker, but actions were not taken. frequently actions can be taken if the error is recognized. So poison control, if it's a medication, poison control is your best friend. Partner with the pharmacy, poison control. They can tell you what to do. So allow for mitigation. If you've made an error and you recognize it, report it and take action to minimize the harm to the patient. It's also important to correct systems issues if things aren't set up correctly. As a risk manager, I always felt my role was to help put systems in place to make it easy for people to do their job the right way and the safe way. Correct procedural issues. Are your policies and your procedures up to date and up par with national standards? Sometimes we need additional education. Things that are especially worrisome are things that are high risk and low frequency. So you don't see them very often, and there's a special risk associated with that. One of the most important reasons why reporting matters is to prevent future harm, which we've already touched on. And when you go into practice in states and such as New York, there are regulations regarding reporting specific events. So wherever you end up practicing, you'll want to know what those are. With that being said, when you report a safety event, it's really important that you not note the safety event or the details of that in the medical record. You do not put in the medical record that you filled out an incident report. Next slide, please. So who's reporting? Who should report? Everyone should report. Everyone who is involved in the event should make sure that event was filled out. Next slide, please. So on this slide, I have a few thoughts on how we can facilitate safety event reporting or incident reporting. I like to call it safety event reporting. Simplify the reporting system. We need to have education and talk about near-miss safety events. We need executive leadership in the organization to say patient safety is important. And we need our leaders to support us for reporting. I support setting up a system to recognize employees and nurses who are safety stars. At Bassett Healthcare, we actually have what's called a scorecard, and we track the percentage of near-miss events that are reported in the system, because that gives us the opportunity to prevent future harm to patients. So going back to one of our original slides, 300 near-miss events for every actual error. So that's a lot of opportunity. We evaluate our reports based on the harm score. We prioritize looking at the high harm and potentially high harm events first. And then we talk about just culture, and I'm going to touch on that a little bit. And I am a certified just culture trainer, and I want to touch on that because why don't people report? Why don't we report errors we make? Because we don't like to talk about the mistakes we've made. It's just part of our human nature. But it's important that we create an environment where it's safe to report. And that's what just culture is about, psychological safety. Let's go to the next slide, please. So some of the first literature I can find on just culture was really came out of an organization called Outcomes Ingenuity. And they talk about how important it is for it to be safe for people to report error. Now, this doesn't alleviate accountability, but it makes it important for us to share errors. Hey, this happened to me. It could happen to you. Don't do this. Don't do what I did. This was used very successfully by several high-risk industries, such as the airline industry and nuclear power industry. So healthcare is coming around to this, but around to this quite a bit behind other industries. So here's our friend Lucian Leap again, Dr. Leap saying, you know, the greatest impediment we have to error prevention in the medical field is that we punish people for making mistakes. So historically, what we've done is the sometimes there's punishment related to the outcome of the mistake. It could be a simple mistake, it could be a slip. And depending on how significant the outcome was, we tended to punish or penalize people for the resulting error and not actually look at how the error occurred. So that's really what just culture is about. It means we evaluate systems and processes instead of blaming an individual. Next slide, please. So there are really three behaviors that are recognized in a just culture, and that is human error, which is an inadvertent action, inadvertently doing something other than what should have done. So you fell up the stairs, you dropped your book, you made a mistake, you looked at something and you could have sworn it said something else. The print you were looking at said something else. Your brain just registered it differently. That's human error. At-risk behavior is when we say, well, we know we really shouldn't do this, but this time I'm going to do it because I'm in a hurry. This time I'm going to do it because it'll be okay because I've done this before and nothing's happened. Reckless behavior is when there is a behavioral choice and a conscious disregard for substantial or unjustifiable risk. And I'll go over some of these momentarily. Next slide, please. So an example of human error. This is an example of human error. Do you know, but this happens about 10,000 times a year. And people drive away with their with the gas hose still hooked to their car. If you notice on the right-hand side on the bottom, there is a special coupler that goes to the gas pump that allows this to break away so that there isn't an explosion or damage done to the gas pump. So this is an example of human error, and the coupler on the end of that is a compensatory mechanism that makes up for that. Next slide, please. Drift is human. Okay, so this is us. This is at-risk behavior. You know, we're on the thruway or we're in town, and either we're not paying attention or we're in a hurry, and all of a sudden we're above the speed limit. You know, on the thruway, every 5 miles an hour, you go faster over the speed limit. The chances of you getting in a car accident and suffering significant injury are exponentially increased, but we still do it. We're still going 75 and a 65. Next slide, please. So I'll ask you if this is at-risk behavior. So it certainly looks risky, but we're going to talk about if this was actual risk, high-risk behavior as people felt. This particular photo got a lot of really negative reaction from people for what seems to be obvious reasons to us. So with just culture, we're going to look at an algorithm, and this is what we use in a just culture to evaluate risk and action. Next slide, please. So in a just culture, this is an algorithm that I modified from outcome ingenuity algorithm, and I kind of combined it with Press-Ganey and kind of combined them together so we could fit it on one screen. But if you look at the top left-hand side, were the actions as intended. So if we were thinking about the gentleman with the baby and the crocodile, they were definitely intended. Was the outcome as intended? There was in that case, there was no bad outcome other than there was a public outcry. Was there impairment? No. Was there knowingly violated safety practices? This is where this gentleman got into trouble because it was felt that he was violating the safety policies. And this is where organizational policies come into play, organizational policies for safety. So, but in the top right-hand corner there, does it pass the substitution test? He is an animal trainer. And when there was conversation with other animal trainers who were trained the same way, They did not feel he was taking a risk. They felt it was safer. That was his child, and his children were always around crocodiles and alligators, and they felt it was safer for the child to be raised around the animals than to be brought about around the animals or crocodiles when they're little older. So they did not feel that that was a substantial risk to that child, and they didn't see it as a problem. Let's talk about another situation. We'll go back to medications. Nurse was in a hurry. So policy is supposed to remove medications from the Pyxis machine, from a medication dispensing cabinet, on one patient at a time and administer it. So she's behind, so she intends to get caught up, and she takes the medications from 2 patients out of the Pyxis machine at the same time. She puts them in her pocket. She goes into the patients in a semi-private room, and she goes by the barcode scanner. We didn't use it, and gives one medication in her pocket to the wrong patient. So now we have a medication error. So when we evaluate that and evaluate the error, were the actions as intended, the answer is no, step 1. To step 2, suspicion of impairment, no. Step 3, did she knowingly violate standard practices or procedures? The answer there was yes. Were the standard procedures available and workable, intelligible, and correct? And the answer in this case was no. The nurse was supposed to give the medication with a certain number of minutes from when it was due, and there was a long line at the Pyxis machine. So when you asked the question, the line at the Pyxis machine was very long, and she knew that her other medications would be too late. So the standard procedure that was available was not workable. So if you follow that down the no trail there, it comes to the green box on the right. This is a system-induced human error. So there was a behavioral decision. There was a decision to take a shortcut and put the medications for 2 patients in her pocket. But when one looked at this, the issue was, part of the issue contributing was the fact that there were not enough medication dispensing cabinets for the unit that this was on. And in fact, there needed to be another medication dispensing cabinet so people weren't standing in line, nurses weren't standing in line to get the medications out. So that was the answer. So up on step 4, does it pass the substitution test? The answer would be the substitution test is someone in a similar situation do the same thing. And the answer was yes, because what we found out is because there was such a line for getting the medications from the dispensing machine, several people were doing this. So this is where just culture comes in. We're evaluating the systems and not just looking at the person. Next slide, please. So what is the biggest opportunity and/or the biggest threat to safety? It's at-risk behaviors. Shortcuts and workarounds are the enemy to safety. These policies and processes that are in place are there to help you and to provide safe care to patients. So follow the policy. If you're having an issue and there's an improvement recommendation, go to your manager, talk to your manager about it. If you have safety technology available to you, pumps, bed alarms, barcode scanning for medication, use them. If they're not working and you have a high-risk medication, as an example, get someone else to double check your dose if you're not sure of it, or your medication. Next slide, please. So what do we do when we have an error? We use the root cause analysis process developed by the National Patient Safety Foundation. It's an excellent process. Again, this would be something we could talk about for 20 minutes, and I will not. But what it does is evaluate the entire system and not just look at the result. Next page, please. The way this happens is we look at what's called an Ishikawa, or a cause and effect diagram. And there's things that on every arm here, these aren't always the headings, but examples of this, we have a patient who we already know is at risk for some kind of complication. Environment, if the patient fell, is the floor uneven? Is there a crack in the sidewalk? Did their equipment fail? Work methods, is our policy sufficient to protect the patient? Are we doing everything we can to help create a safe environment? Personnel, did we have proper education to use equipment that we're using? Is this someone who's just off of orientation? Do we have a hole in our orientation process? These are just a few of the things we look at. Next page, please. Once we have determined what the root cause is, or what the true cause is, we start looking at corrective actions. And this is from the RCA2 process book. And you can see some of the stronger actions are related to engineering control, such as help with technology, help with IT, simplifying processes, and making sure that we have the equipment needed and that leadership is involved in helping with the corrective action. What's really interesting here is some of the weaker actions through research have been proven to be double checks, warnings, and training. Although sometimes we do need training, we do need orientation on new equipment. But when there's errors and trends and errors happening, retraining is not always the answer. Next page, please. And with that, I want to thank you for your time and attention, and I will turn this back over to Kathleen. Thank you very much.
Thank you, Paula, for that presentation and that information. So valuable, and what our students need to hear. Then I'm going to introduce our next presenter of the evening, and that is Karen Butler. She's a registered nurse. She has her Bachelor's of Science in Nursing, and she's also has her Juris Doctor. She combines more than 20 years experience as a critical care nurse with her skills as a practicing attorney. Her areas of practice include medical malpractice defense, professional misconduct, health law, and civil law litigation. Karen is admitted to practice law in all the courts of New York State, in both the Northern and Southern Districts of New York, and in the United States Supreme Court. Karen graduated magna cum laude from Albany Law School in 1995. Karen was the associate editor of the Albany Law Review and recipient of the Selma Minst Memorial Prize for graduating with honors while raising a family. Respect that, Karen. Something. That's very impressive. Karen is a member of the New York State Bar Association, the law section of the New York State Bar Association, and the American Association of Nurse Attorneys. She is a past member of the board of the Capital District Trial Lawyers Association and was president in 2009. She has published several articles on health law related topics and lectures extensively on health law, litigation, and professional misconduct. She was appointed by the governor of New York State Task Force on Life and Law in 2003, where she worked on such topics as the definition of brain death and the allocation of ventilators in a pandemic. Well, there's another symposium right there. But that's not what you're going to talk to us tonight about. So I'm going to turn it over to you, Karen, and take it away.
Okay, next slide. And next slide. And next slide. Okay, my name's Karen Butler. I'm an attorney. I'm a trial lawyer. And I try cases in court. I mostly do medical malpractice. I do about 80% medical malpractice. I only do medical malpractice defense. I didn't go to law school to sue my friends. So I am always on the defense side. So my clients are hospitals and nurses and doctors. And people like you guys are going to be. And then I represent doctors, nurses, social workers, pharmacists charged with professional misconduct. So I'll explain to you what that is. I do not do criminal law, but I'm going to talk a little bit about criminal law today, just how it affects your license. Next slide. So, why are you worrying about criminal stuff? Sometimes you can be charged criminally for something that happens with a patient. And Paul talked a little bit about the Redonda Voigt case. And Redonda was a nurse, very busy nurse. She had to go down to the CAT scanner with a patient that was going to have a CAT scan, an elderly patient. The doctor ordered vecuronium for the patient, which is an paralytic agent. I'm sorry, he ordered Versed for a patient, not vecuronium. Versed for a patient to sedate her so she could have her CAT scan. So when this nurse went down there, she had to use the Pyxis in the radiology department, which was not her normal Pyxis. She was trying to get Versed out. And she had to do something called an override to try to get the Versed out. She started to check to put in the letters spelling Versed, and she put in the VE, and vecuronium came up, and the little drawer opened, and she took it, unfortunately, and gave it to the patient. It's a horrible way to die. This person was put in a CAT scanner and was completely paralyzed and could not breathe. I don't know how often you take care of patients that are paralyzed, like in the intensive care unit on a ventilator, but they're always sedated. You would never just leave them wide awake because it's horrible and they're on a ventilator. But this lady wasn't on a ventilator and she wasn't sedated, and she died this horrible death in the CAT scanner. She was charged criminally for something that was just a mistake. And one of the reasons she was charged was the family had gone to the newspapers. The district attorney happened to be running for re-election. So he liked the idea of getting headlines and publicity. It went to trial, and the judge sentenced her to 3 years probation. So she did not have to go to prison. However, she lost her license. She lost her reputation. She spent a huge amount of money, and it was difficult. It was difficult for the family, difficult for the patient, but it was just a mistake. It was a mistake. She never intended to harm her patient. It was just a mistake. There was another case in Westchester County where the nurse was giving blood to a patient. And I don't know if you've given blood transfusions yet, but it's dangerous. And when the blood comes up from the lab, it comes up with a lab slip. Maybe now you scan it, I don't know, but you have to check it with another nurse so that you're making sure you're giving the right blood to the right person. And I have a case now in my office where somebody got the wrong blood and they died really quickly, and there was nothing they could do. Everybody had known they gotten the wrong blood, and there was just nothing. They were slamming the man with everything they could, and nothing helped. He just died. So you check the blood very carefully. So she checked the blood, and you have to check it with another person. She checked it with another person. She did absolutely everything she was supposed to do, walked into the wrong patient's room and gave it to the wrong patient. She got arrested because the patient started to code, and the nurse realized what she did, and she took the blood down real quick and hid it in the garbage can. And it wasn't giving the wrong blood that caused her to be charged criminally. It was the fact that she tried to hide it. And then they charged her with negligent homicide. And she was convicted, and I don't know if she went to prison or not. But it was a mistake that turned into a crime because she tried to hide it. So there have been times when nurses get charged, or times when doctors get charged criminally for things that happen with a patient. Several people got charged criminally for what happened during Hurricane Katrina. I believe the name of the hospital was Mercy Hospital. And those poor people, they were there for days. They were desperate. There was no air conditioning. There was no water. They were running out of food. They had all these people there and no way to take care of them. And they were trying to evacuate them and they couldn't. And some of the people were on ventilators or weighed like 300 or 400 pounds and they couldn't get them out of the building. And they ended up giving them overdoses and they died. So they were charged criminally. You can be charged criminally for things that happen with narcotics. And this is something that I see very often. Work with a lot of strong narcotics. They are counted. Some units count them better than others. If you go home with a drug you meant to discard and you don't, and you go home with it, and you've committed a crime, and you have to go back to the hospital and give it back, and that pharmacy may check it to make sure it is what it is supposed to be. But if you're wasting narcotics, if you're signing off that you're watching somebody waste narcotics and you didn't actually watch them, you've committed a crime. And there are a lot of people that are addicted to narcotics, doctors that are addicted to narcotics, nurses that are addicted to narcotics. But they're crimes and you frequently get caught. There's something called the Bureau of Narcotics. So you can get, let's say there is a problem on your floor with narcotics, and say that particular nurse gets into treatment and she's taken care of, and thank goodness. But then the Bureau of Narcotics comes in and they check everybody who works on that floor. And they bring you in and they put their badge on the table and they read you your rights. And it's not a friendly atmosphere. And make sure you have an attorney with you if you are ever contacted by the Bureau of Narcotics. And it may and they'll go back and they'll say, do you remember wasting this Demerol in this August 2022? And you're going, no, I don't even remember where I was working in August 2022. But they'll ask you those specific questions. They have sheets and sheets of paper that they look at. And so anyway, that's difficult. You can be charged with physical or sexual abuse of a patient. And the allegation may be false, or theft of things from a patient. So things that you can be charged for things that happen at your job. Long-term care, that can be, you can be charged with, there are special statutes for long-term care patients or anyone who is a compromised type patient. And you can be charged with abuse and neglect, which is a crime. And you can be charged criminally by the Attorney General's office. So if we had a case one time, this poor nurse came to us and she had been charged with abuse and neglect of a long-term care patient and ended up pleading guilty. Then she was charged by the education department with professional misconduct. And then she ended up being put on this list called the Office of the Medicaid Inspector General list, which means you can't work anywhere that takes Medicare or Medicaid. And that is everybody. You can't work anywhere if you're on the OMIG list. And what had happened to her, she had gone into work in long-term care and she had been working in ICU. So she wasn't used to going in to she thought long-term care would be easier than ICU. And I worked in ICU for 20 years. In ICU, you've got 2 patients. You might have 3 if you have one person that's ready to be transferred out, but normally you have at most 2. Sometimes you only have 1. So she goes to long-term care and all of a sudden she's got 20. And she was supposed to do assessments and treatments because she was the RN. So she would go in early to get these assessments and treatments done. And she would try to get them done before the residents got up. The residents get up and get dressed. They live there. That's their home. And so she would try to get it done before the residents got up. And there was this one lady who was a real early riser, and she was supposed to do a dressing on her foot every morning. And she forgot. She forgot for 3 mornings in a row. She didn't change the lady's dressing. The next day, the new RN came in and she realized the dressing hadn't been changed and it looked all scummy and stuff. So there's mandatory reporting in long-term care. And she reported it, and then it goes up the chain. You have to report it to the state. So they reported it and they did all the things they were supposed to do. The lady didn't lose her foot. She didn't get an infection. Nothing bad happened to this lady at all. Not one bad thing. It goes to the Attorney General's office, and this woman's outside on her front lawn playing with her kids on Saturday morning, and the deputy sheriff pulls up and she's handcuffed and taken away. And she was charged with abuse and neglect of this patient. So I'm not saying you shouldn't work in long-term care. I'm just saying that they have special rules. And you can end up getting charged criminally. If you read about somebody being charged with some of these things in the paper, and they always make the paper, there but for the grace of God go you, really. Criminal charges for something that happens outside of work. If you get arrested and are convicted of a misdemeanor or a felony, that gets reported to the nursing board. And it's automatically professional misconduct. It doesn't have to have anything to do with nursing. It doesn't have to affect your ability to be a nurse. We had a lady who was charged with arson. We had a lady that was charged with bankruptcy fraud. Most of the time it's a DWI. And if it's a misdemeanor or a felony DWI, then that's automatically professional misconduct. So if you do get arrested for something like a DWI or drug possession or whatever it is, you have to make sure that your criminal attorney knows that you're a nurse, that you have a license, and they need to contact an attorney that can help to advise them on what kind of things you can actually plead to help to try to limit your exposure as a nurse and save your license anyway. Next slide. So licensure actions. This is your state board of nursing, and it's the Office of the Professions. It's the education department. They are the nursing board in the state of New York. How do you get reported to the Office of the Professions? You are automatically reported if you get fired by the hospital or a nursing home. You're going to get reported. Anybody can report you. Anybody. Your spouse in the middle of a messy divorce can just decide to pick up the phone and report you just out of spite. Anybody can report you. They can report you anonymously. You will never know who reported you. They will not tell you. It's confidential. You're automatically going to get reported, and it's automatically misconduct. Like I said, if you're convicted of a misdemeanor or a felony. Also, if you're found guilty of misconduct in any other state, you're going to be charged with misconduct in New York. So it doesn't help you to move. It doesn't help you to get licenses in other states because you're still going to get charged with misconduct. Lying on your application or renewal is misconduct. So let's say you have a criminal conviction and you get your renewal for your license and it says, since you last registered, have you been convicted of a misdemeanor or a felony? And you say no, they find out, they know. The district attorney will report to the Office of the Professions if you get a conviction, and they will report you. PAP is that branch of the education department that helps impaired professionals. So if you have a drug or an alcohol problem, you can go to PAP. It's a wonderful program. You surrender your license for 90 days. They do drug testing. You either go to rehab, or you may be able to be treated as an outpatient. And so you don't have your license for 90 days, and then you can get your license back in 90 days. But then they continue to monitor you. So they want you to work. They don't want you to work nights. They don't want you to work in an area of the hospital where they're loosey-goosey with narcotics, say in the emergency room or in the operating room. They want you to have a nurse monitor. They want the hospital, of course, has to be aware. They have to continue to have your urines checked for 2 years. They want you to continue to go to AA, NA meetings, that type of thing. But you save your license. You might not just be saving your license. You might be saving your life, but you'll save your license if you do that. And this is another one of those things there, but for the grace of God, because you might think that would be terrible and the hospital would never hire you again. You'd be surprised how many people that are in PAP are working in the hospitals where you're working, because it's a well-recognized program and it does a lot of good. If you are contacted by the Office of the Professions, they may call you on the phone. Their first contact may be a letter, or it may be the phone call. And they'll say that they just need to talk to you to clear something up. Why don't you come in? Or maybe I could just interview you on the phone right now. That'd be fine. You can't just go off and interview these people by yourself. You have to have an attorney with you to protect your rights. They are not going to tell you, they may tell you that you have a right to an attorney. They're not going to tell you that you should have an attorney, but you should have an attorney. You can get a much better resolution of your case if you have an attorney, and they'll help to limit exactly what's going to happen with your license. So it's important if somebody calls you up and says they want to talk to you about something that happened at work, or talk to you about why you left such and such a hospital, or why you were fired. It's very important that you get an attorney. I'm going to answer one question that you're probably going to ask, that sometimes people ask, is whether or not they should get their own malpractice insurance. You do not need malpractice insurance to protect you from lawsuits. Nurses very rarely get named individually in a lawsuit. If you're working for a hospital or working for a medical practice, you'll be covered under their insurance policy. And that insurance policy will protect you. The hospital will protect you. The only reason, though, I sometimes recommend to people that they get their own medical malpractice insurance is because it will pay for you to have an attorney if you are charged with professional misconduct. So that can make it a lot easier to defend yourself if your license is on the line. And I tell people, people are worried about getting sued. If you get sued, lawsuits are only about money, and it's not your money, somebody else's money. They don't want your money. They don't want your house. They don't want your car. They don't want your 401k. They want money from the insurance company. That's all they want. I've never seen them try to go after anybody's personal assets. When you're going to lose your house and your car and everything is if you lose your license. So that's why it's important that you get an attorney for that part of the process. But be that as it may, we're not going to talk about medical malpractice. So the next slide, please. This is what I do most of the time. I do professional misconduct maybe 20% of the time, but I do medical malpractice a lot. Medical malpractice is defined as doing and this is actually from the jury instructions. This is what the jury instructions are. Doing something a reasonable and prudent provider, a doctor, nurse, PA, doing something a reasonable, prudent provider would not do or failing to do something that a reasonable and prudent provider would do. It's a deviation from accepted practice. And there are certain elements in any negligence case. Malpractice is professional negligence, but in every negligence case, there are 4 elements. First, you have to prove that there's a duty, that that person owed you a duty. If you're taking care of a patient, you owe that patient a duty. Now, there are some times when you are immune from liability for helping a patient. And one of those things is if you're helping somebody in an emergency. So if you stop on the side of the road to help somebody in an emergency, or you just help somebody on an airplane when they call for a doctor and nobody stands up and you're like, oh, I'm a nurse. Can I help? You can't get to your, every single state in the United States has an immunity provision for helping someone in an emergency. So please stop at the car accident. The only exception to that is if you put the person in a worse place than they were when you found them. So you can't drag them from the side of the road and put them in the middle. You can't say, I'll call 911 and then drive away and go to a party. But as long as you are just trying to help them and don't put them in a worse position than they were before, you cannot get sued. So that's a little aside, just so you know. In case there's an accident on your way home. Well, you're not, I guess you are home anyway. So it's doing something a reasonable and prudent provider would not do, or failing to do something a reasonable and prudent provider would do. It's a deviation from accepted practice. The plaintiff, that is the person suing. So the person suing is called the plaintiff and you're the defendant, unless you're suing somebody, but normally you're the defendant as the nurse. The plaintiff has the burden to prove what the standard was on that date under the circumstances that existed at that time. So that sounds easy. The plaintiff has to prove, and you have to prove, you don't have the burden to prove, but you're going to have to put evidence in what the standard was. And how are you going to do that? Because you know what? There is not a single nurse on that jury. There's not a doctor, there's not a PA, there's not anyone with any medical experience on your jury. They almost always all get kicked off your jury. So you have a bunch of people there who don't know anything about hospitals or what it's like to take care of patients or how to deliver a baby. They don't know. I had a trial in Herkimer, New York. And it was a shoulder dystocia case. And a shoulder dystocia case is when a baby's being born, sometimes the shoulder can get stuck behind the pubic bone, and that's called shoulder dystocia. And then the doctor has 2 minutes to try to get the baby out, because while the baby's stuck, the baby's not getting any oxygen. So the doctor has to try to do maneuvers to get the baby out. And the doctor did get the baby out, but the baby had an injury to the brachial plexus, the pile of nerves in your neck, and so had weakness of the right arm. The nerves were stretched because the neck was stretched. So we're picking the jury, and I say to the jury, you know, does anybody have any medical experience? Da 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 da. And this one woman was a veterinary technician. I said, oh, that's interesting. Have you ever delivered an animal? She says she delivers animals every day. I said, okay, because this case involves there was a cord around the neck and then the shoulder got stuck. And she was like, oh my God, that cord's awful. You never know what's going to happen to the damn cord. And then, so I said to the jury, the rest of the people in the jury box hadn't been picked yet. I has any chance anybody else ever deliver an animal? And every hand went up. And the judge said, this is Herkimer. We deliver farm animals. So I went back to the table and I said to the doctor, you are finally going to have a jury of your peers. And they were the best jury I ever had. So if you get sued for malpractice, try to get your trial moved to Herkimer. Anyway, so what we do is we have to establish what the standard is to respond to the expert that the plaintiff calls. So the plaintiff will call an expert, and then we call an expert. And the expert has to try to explain to the jury in language that they'll understand what the standard of care is for a nurse in that situation. And the experts have to address causation, because you have to prove that the negligence actually caused the injury. And there has to actually be an injury. The person must actually be injured. They can't say, you made a medication error. Yes, I know. You were negligent. Sure was. I'm going to sue you. Okay. And then it's going to get dismissed because they don't have an injury. You have to have an injury. The other way they can establish the standard of care is by the hospital's own policies and procedures. And one of the ways that they can't usually is by, like, what you would think, maybe your Lippincott manual or something like that, because in order to do that, somebody in the trial would have to say that that's an authoritative source. And since we all know not to say that, that doesn't happen. Next slide. So when there's an event, and Paula talked a little bit about an event, do not discuss the event with anyone except your attorney or as part of quality assurance risk management office. Don't just go around talking to people. So there's something happens to the OR and you want to talk about it. Don't talk about it in the staff room. Don't decide you have to talk about it to the doctors. Don't decide to talk about it with the anesthesiologist. Don't talk about it. Don't go home and write it up. I can't tell you how many times nurses think they have to go home and write it up. No, you do not. You don't have to do anything like that. You don't want to do that. That is admissible. We don't want extraneous information admissible. Don't keep notes or diaries about anything that involves the patient. Even if you have a personal diary that you write in, if you start writing in it about your day and what was going on that day, then all of a sudden your diary is admissible. So you don't want to do that. We're trying to keep things just in the chart. We want the facts in the chart. We don't want your opinions. Complete an incident report the day of the event because you want to be fresh in your mind. Don't make a copy. Don't fax it to anybody. Don't email it to anybody. Don't text it to anybody. The incident report is going to be privileged. And privileged means that the court, that New York State, because they want people to have QA programs, they make the QA process privileged. So if you maintain the integrity of your incident report, you're not going to be waiving your privilege to keep that document privileged. All you want to put in the incident report is the facts, just the facts. You don't have to speculate. So, like, this is a classic example. You go into the room, you find the patient on the floor next to the bed, and you're like, oh, Mr. Smith, what happened? He goes, I fell out of bed. Don't write in your incident report, patient fell out of bed. You have no idea if this man fell out of bed. He might have gotten up. He might have been walking to the bathroom. He might have decided to get up and sit on the floor. You don't know. You only know that you found the patient on the floor next to the bed, and he said, I fell out of bed. All right? Just the facts. Don't fill in the blanks. Be truthful in every step of the process. We can always deal with facts. Your attorney and the risk management office and the QA people, we've seen everything. We can deal with anything. We can't deal with finding out stuff at the end or having new things come out at the end. We need to know what the facts are so that maybe this is a case that should settle. But if you tell me all along that the facts are one thing, and then it turns out there's something else, then the case hadn't settled and we're in the middle of the trial. So tell us the facts. Don't spin, just tell us the facts. Next slide. The record, the medical record. I hate electronic medical records. I hate them. There's nothing good about an electronic medical record in my world. They may be wonderful in your world, but they're not good in my world. The paper record was so much easier for me anyway. The record is Exhibit A. It's always marked as Exhibit A in a trial. Always. It's the medical record. Cases drag on for years. I have cases that are going to trial. I have a trial in October, and everything happened in 2016. Cases take a really long time to end up to wind down and go to trial. And you may not remember everything. Well, you're not going to remember everything that happened. You may not remember what happened 2 weeks later. Because you might not have known anything happened. Sometimes you don't even know anything happened until, 2 years after the patient went home. So you want to be sure that you're charting. Well, let's see. The chart is the best and most probably only proof of what happened. And the jury gives a ton of credit to the chart. They're going to believe the chart over your oral testimony or your memory. Next slide. Okay. We don't have your electronic medical record software in my office or in any attorney's office. We don't have it. Let's say you work at a hospital that uses Epic. I don't have Epic on my computer. I've never sat down and used an Epic software program. I may get the chart electronically, but what I'm getting is electronic, like scanned version of the chart that is not what an electronic medical record is. It's 1,000 pages. It's at least 1,000 pages. It ends up just being all this stuff. If you're working in which almost every healthcare system is, an integrated healthcare delivery system, then you're going to get every single visit that person ever had in any of the satellite locations, any x-ray they ever had, anytime they went to the emergency room, every visit to their primary care if they're part of their system. So you get this gigantic thing. And then I'm trying to find the chart that's actually has anything to do with the lawsuit. And it's a stagnant copy. The electronic medical record is meant to be an interface between the person using it and the system. It's not, I don't get drop-down boxes. I don't get the alarms that you saw. I don't get any of those things. I don't even see how this chart works. So I get this static, dry copies of the record. Part of the record, part of what's kept, and part of what plaintiffs' attorneys ask for, and in fact, one hospital I represent includes it in the record every time we get it, is something called the audit trail. The audit trail shows everybody who's gone in the record, what time they went in the record, what they put in the record, any words that they changed, what they took out, what they put in. You get the audit trail. So sometimes you'd be asked even about that. And as you know, when you're charting in the record, the time of documentation is captured, not the event time. So you have to be sure that in the body of your documentation, you're putting down what time the events actually occurred, so that time becomes minutes. Like in a shoulder dystocia case, you have to get that baby out in 2 minutes. So people are looking at minute by minute, second by second of what was happening. One more, next slide, please. Okay, a deposition. If you do get sued, if you get named in a lawsuit, you're going to be asked to give a deposition. You're probably not getting a deposition because you're named in a lawsuit. If you're named in a lawsuit and somebody knocks on your door at 8 o'clock in the morning on Saturday, hands you an envelope and says you've been served, you bring that to the hospital and give it to the risk manager. Don't keep it. And it's very time sensitive. You have to give it to somebody right away, right? That includes if you're getting sued for a dog bite thing, don't go to the hospital with it, but you want to get to your insurance company or your insurance agent right away. Give it to somebody. All right. When you're going to give a deposition, don't speak to anyone, including any coworkers, about the case. Don't talk to other people that have been given depositions. Know what your role is. Are you actually named in the lawsuit? You're probably not. So you're probably just a witness. Even if you were the main person involved, you're considered a witness. Don't go into the system to review the record. You're going to meet with the attorney and go over the record. And you're probably, depending on how important your deposition is to the case, if you're the main person, you're probably going to meet with the attorney more than once. Know the record. Know what it's going to look like at the deposition. Know where to find your notes. It's not going to look like it did when you were doing it. Let the attorney know where stuff is and what stuff is there. I mean, a lot of attorneys don't know that vital signs might be on another record, or there's a pain management sheet that's on another record. They don't know that. They're attorneys. They don't know that. Next slide. Depositions are part of discovery in a lawsuit. There's a lot of discovery in a lawsuit. A lot of it has to do with asking for policies and procedures, getting all the medical records, getting the names of witnesses and stuff like that. It's part of the discovery process. You are under oath. If you lie, it's a felony and you'll go to prison like Martha Stewart. So you're going to tell the truth. The attorney for the plaintiff is going to ask you questions. I'm not going to ask you any questions. If I want to ask you a question, you don't have to be under oath in front of another person. If there's a co-defendant, so let's say a doctor's being sued and maybe another nurse, and then I'm representing you. So they're all going to be there, but the attorney for the plaintiff is going to ask you all the questions. The attorney for the other people may ask you one or two softball questions, but they're not going to be grilling you or anything. But the plaintiff and the plaintiff's attorneys are all different. Some of them come across really, really, really nice. Some of them throw chairs across the room. It doesn't matter what they do. It's an act. They've developed an act that works for them and they stick with it, and that's what they do. But it doesn't matter. None of them are your friend. Next slide. The stenographer is there. She administers the oath. She takes down every word you say, which means you must talk in words. You have to answer everything in words. Only answer the question you're being asked. If you don't understand a question, don't answer it. Say, I don't understand the question. Can you rephrase the question? Next slide. Answer the questions asked, then stop talking. Wait patiently for the next question. Be honest. Again, I keep telling you to be honest. You're under oath. Don't guess. Don't speculate. Don't say you know something that you personally do not know. For example, they'll say, does your employer keep records about who was working that day? And invariably, the nurse will say yes. I'm like, are they in your garage? How do you know? Maybe they had a computer crash. Maybe they don't have those things. If he wants something, he'll ask me for it. He doesn't have to ask you. Next page. Follow the directions of your attorney. Be professional. Be factual. This is not the time to bring up the grievances you have against your coworkers or your employer. It's not the time to say, staffing just wasn't safe that night. It's terrible there. Nobody listens to us. It's not the time. No active listening. Nurses are frequently guilty of this because they are used to active listening and trying to encourage their patients to talk. So they sit there with the plaintiff's attorney and go, That is not necessary. You don't have to encourage him. Ask for a break if you need one. Don't just talk. Answer the question and stop talking. Next slide. After the deposition, you get a copy of your transcript. I won't go into that. Next question. Next slide. Okay, I want to talk to you about, that's the professional misconduct part. I want to talk to you a little bit about social media and professional misconduct. There was a case, there have been some cases involving social media and professional misconduct. So next slide. So this case involved a nurse in Syracuse who thought it would be funny to snap photographs of an unconscious patient's penis and put it on Snapchat. Kristen, and Kristen, surprisingly, many people did not report her, but someone did. And she was charged with misdemeanor for sharing for unlawful surveillance. And she lost her license, not surprisingly. Next slide. As part of the plea deal, they got rid of her felony charges. And then she had 3 years of probation, criminal probation, but her license was revoked for moral unfitness. Next slide. And then I just wanted to there was a thing going on a couple of years ago where nurses it wasn't just this woman, it was like a little thing crossing the United States where nurses would take pictures and put them on Snapchat. And it was all over the country. It was crazy. It was awful. It was a terrible thing to do. I don't know why people thought that was funny. I have no idea. But anyway, next slide. And in addition to the photos of the male patient's private areas, she also had shots of somebody cleaning out the blood clot. It was disgusting. Next slide. All right. What is considered a HIPAA violation? Under HIPAA, a breach or violation is impermissible use or disclosure under the privacy rule that compromises the privacy of protected health information. Next slide. And I'm sure you've learned a lot about HIPAA already, but I want to show you some of the things, the way HIPAA comes up in social media. So some common examples is like posting some gossip about a patient to unauthorized individuals, even if the name is not disclosed, sharing photographs or any protected health information without consent from the patient. Next slide. Mistaken belief that posts are private or that they've been deleted, sharing of seemingly innocent comments or pictures. And the example they give is like you're in the workplace having lunch with people or sitting at the desk and there's some identifiable patient information in the picture that you post. Next slide. According to Health and Human Services, the majority of HIPAA violations occur from employees mishandling professional health information and on inappropriate social sharing. Next slide. Violations under HIPAA include very extensive and expensive fines that can be anywhere from $100 to $1.5 million. Next slide. So you know that. You all think you know that. Thought I knew that. And I'm sure I'm not listing everything, but it's Facebook, Twitter, Snapchat, Messenger, texting, email, smartphones, and I should have my granddaughter update this list. Next slide. So we had one case where the nurse posted on Facebook that her patient fell and the nurse, not the patient, ended up covered in poop. So she comes home, she works nights or whatever. She's tired. She had a bad night. She wants to post something on Facebook about what a horrible night she had. And she puts on Facebook that her patient fell and that she, the nurse, ended up covered in poop. Next slide. Or let's say this happened too, where a nurse actually, a nurse ran into a friend who had her daughter was in the hospital. She said, "Oh my God, what are you doing here?" She said, "Oh my God, Susie's in the hospital. She's on PED. She was just diagnosed with cancer." And this is one of this nurse's good friends. And she goes to see her, of course, and she takes a selfie with this little girl, and she's got her uniform on and she's got her name tag and her badge and everything. And next slide. And she's concerned. And so anyway, I guess I didn't need the next slide, but she posted on social media on Facebook the picture, and her friend's other Facebook friend reported this woman to the hospital for violating HIPAA because she posted a picture of a patient and put it on Facebook. And the nurse got fired because the hospital had a zero tolerance policy and they fired her. This was a case that involved a nurse who found out that her patient had a GoFundMe page. So she wanted to donate money. She had a really sick patient. She wanted to donate money. So she went into the GoFundMe page and donated money. Next slide. And in that case, she could end up, if she discloses information, so like discloses that the patient's in the hospital, something like that, she has violated HIPAA. So other ways, things you can do with email and texting, like you forget to give medication to a patient, and you go home, so you text a coworker and say, oh my God, I forgot to give, bed 3 his ampicillin or whatever. Your phone is not protected. You don't have a phone that is tied into your Epic system or whatever electronic medical record you have at work. Your patient falls during the night and you email your manager about the incident. Your emails are all discoverable. They are not protected. And you can't just email things about what happened unless you're using some kind of communication device that's like in the hospital and protected, and you've been told that for some reason you can use it, which normally you can't. You can't go around emailing your coworkers about a patient or texting them about a patient. Next slide. It's all discoverable. You email a copy of the Monday OR schedule to a coworker who's on vacation. Man, so you've got the name of every patient and what surgical procedure they're going to have, and you just emailed it via like just random email to some maybe coworker in Bermuda or somewhere. That's a big HIPAA violation. Or doctors will take pictures of the OR schedule before they leave for the day, so they know what their cases are going to be the next day. That's a HIPAA violation. They don't have protection for their phone. They don't have protection for that picture. Next page, next slide. People have this mistaken belief that the communication is privileged and is only going to be received by the intended recipient, and that's not true. Next slide. Next slide. Next slide. It is not acceptable to discuss by reference residents or patients, even if they're not identified by name, or if they're just referred by a nickname or a room number, a diagnosis, or a condition. That's a breach of confidentiality. So if you're texting your coworker and you're saying, the gallbladder in room 3, that's just as bad as if you said his name. Next slide. Patient blogs and web pages. Many patients and their families have web pages and blogs so that they can keep their families updated. And what if you put something on the patient's page? Next slide. So we had a case where a patient and his wife had a web page to share information with family and friends about a terrible accident they had. And that happens all the time, where people have these web pages so that they don't have to constantly deal with, talking to family and friends every day. And Susan, the nurse, finds out about the web page, so she goes on and next slide. And so the wife gives her the web page, and she goes on it, and she says, "Oh, I know it's been so hard for you. Hopefully your surgery tomorrow will go well." Well, nobody knew he was having surgery. That wasn't anything the family had shared with anybody. You can't write that. Just don't go on these web pages. Don't go on these GoFundMe pages. Just don't do that. Next page. Next page. Also patient portals, you just want to be careful about the entering information on a patient portal, and God forbid, don't enter on the wrong portal. Next page. Never take a picture of any patient or any visitor without their consent, and don't take it on your phone. So like, let's say you're in nursing homes, take pictures all the time. For one thing, they have written consents and they use something called a secure camera. They're not just using randomly their people's phones. Next page. In some places, the medical students and the residents like to take pictures of patient records. I don't know why, but you can't do that. You can't take pictures of the record and store it on your phone. Next page. All right. So what can happen? Discipline or termination by your employer, referral to the nursing board, the state education department, OMIG, the Office of the Medicaid Inspector General that I told you about, where you may be precluded from working for any Medicaid patient for 5 or more years, or OIG, that precludes you from working for any facility that receives any Medicare. Next page. The Attorney Generals are ones that prosecute for neglect and abuse, and the Justice Center for protection for persons with special needs. Next page. Okay. So in a lawsuit, the plaintiffs will go on your Facebook page, they'll go on all your social media, and they will get anything that you have on there. Next page. Next page. Next page. I do that. So I do that. I Google, if when the plaintiff sues somebody, I Google their names. I Google the names of the witnesses they give me. I look at any social media they have. So, you know, I look at Twitter, I look at Facebook, I look at LinkedIn, I look at anything that I can find. We can serve a subpoena on Facebook, on Twitter, and we can get your past posts, even if they're private, and we can use them when we're cross-examining you. Next page. And we do that. So these are the kind of things people have posted on Facebook, nurses that I've represented. Somebody posted that they were overworked and short-staffed. Somebody said, oh, because they had an awful day because the resident fell. If you're liking, posting, sharing, texting, because we can get your phone, they can do a forensic examination of your phone when you're supposed to be working. So like you're being sued because somebody fell or somebody got the wrong medication, and they get your phone or they get your Facebook and they see that that's what you've been doing. Saying anything about grievances or complaints that you have about your workplace. We had one case where the guy posted that he couldn't wait to get out of the hospital to start his vacation. And of course, something bad happened. Next page. So this is another post. This was one of my favorites. Doesn't anyone around here have any work ethic? Man, do I need a new job? And here was the one. Horrible day at work. Resident fell. I got covered in poop. Or had to stay late due to an incident. Or working late. I need wine. Next page. So these are the cross-examination questions. You don't think your coworkers work very hard, do you? So when Mrs. Smith fell and fractured her hip, your main concern was whether you got some feces on your uniform, or you just couldn't wait to get out of there, could you? That's why you didn't help Mrs. Smith get out of bed to get out to the chair. Or you were more upset about having to write an incident report than how Mrs. Smith was. How often do you drink? Were you craving alcohol? Is that why you wanted to get out of there? So that's how that goes. It doesn't go well. Anyway. Next page. And I'm done. Thank you very much.
Thank you very much. Holy moly, there is a lot
Sorry.
to talk about there. That was very informative also. I'm going to select a few questions just in the interest of time that that we've got like 9 or 10 questions in our chat, but I'm just going to pick a couple. And one question is from one of our juniors. What is the statute of limitations on criminal charges against nurses?
The statute of limitations would, I don't do criminal law. So I probably shouldn't even offer an opinion. I know there's no statute of limitations for murder. There's different statutes of limitations for every different kind of criminal charge. So I'm not sure the criminal charge statute of limitations. Statute of limitations for medical malpractice is 2.5 years. The statute of limitations for wrongful death is 2 years. The statute of limitations for a civil rights violation is 3 years. The Office of Professions and that the nursing board doesn't have a statute of limitations. They can charge you for something that happened 15 years ago if they feel like it.
Magna cum laude there. You just rattled that off the top of your head.
Well, I didn't know the criminal ones.
No, this is from one of our professors of psychiatry. In their class, they've been discussing the Michelle Huggins case in the psychiatric mental health nursing. Can you speak about the liability of that nurse, if you're familiar with the case, either of you, during these restraint and seclusion? Do you know that case?
I don't.
No. Okay. Okay.
So regarding restraint and seclusion, if the restraint Office of Mental Health has very different parameters for what's acceptable over, like if you're using what's considered a safety restraint, say you had a patient who was confused and had an arterial line, safety restraint, and I'll refer to New York State, safety restraint, you can use them, the time they can be on, the time they can be released is different than the restraints you would use in a mental health situation. I apologize, I'm not familiar with that particular case.
That's all right. Bangley, one of our students asks, in case of an emergency and everything is happening so fast, how do you provide a minute-by-minute report of what is happening when documenting? Are you just supposed to say first, second, et cetera? Just like explaining those. I think probably she was thinking about that shoulder dystocia case where.
Yeah. A lot of times when a woman's like in labor, there really are minute-to-minute things because the fetal monitoring strips have times on them. And the same if you're in the cardiac care unit. So the cardiac care unit strips are gonna they have times on them, so you can tell when the person like went into ventricular fibrillation or whatever. What happens in a code? You have a person who's designated. So you call the code, and you have the crash cart, and on the crash cart is the code sheet, and there's always a person designated, usually it's the supervisor, designated to be the recorder. So you know when the code started from the monitor, and then that person really is charting minute by minute. So you're charting, that you gave epinephrine at 12:01, that you gave a second dose of epinephrine, and you're writing all the minute by minute things that happen. The other thing is we explain to the jury that things are not happening sequentially. So like in a shoulder dystocia case, there are certain things that all happen. You call the pediatrician, you are putting the woman up in McRoberts, you're applying suprapubic pressure, you're calling in extra help, you're holding her legs up, and the plaintiff's attorneys will try to make it sound like, so what did you do then? And what did you do then? And what did you do then? And that's not what it is. It's that when we try to explain, we explain to the jury, everything is happening at the same time. It's all happening at the same time.
Yeah. I'm going to pose this question to both of you. Maybe we'll make this our last question, but this is from Jack McGee's, one of our students. What is the most important piece of legal and safety advice you would give to a new graduate nurse?
My advice would be to use the safety tools that you're given and avoid shortcuts and workarounds. And if you need help, if something's, If you have a question about something and you need help, just don't be sure to ask for it. Don't be scared to ask for help.
It's good.
Yeah, I would
Yeah.
say document. Just when there's a bad outcome, a bad thing that happens, you want to be sure that you've documented and documenting the facts. Don't document your opinions about what happened. Don't go out of your lane and start documenting things that the doctor should be documenting, but document, all the things that you did and how the patient responded. Document every single time you notify the doctor about something. It's amazing how many times people don't. And they'll say, I know I must have called the doctor when her blood pressure went down to 70/40, because I would have, it's not there,
Right.
and so you really have to document everything that you do and how you tried to get help. And let's say you're calling the doctor and the doctor's not responding. And you document that, I paged the doctor at such and such a time. I paged the doctor in such and such a time. I notified the supervisor that I was not able to reach the doctor, take things up the chain, so that she can get you additional help so that you can get orders to take care of your patient. I worked a lot of nights, so.
20 years. Yeah. I just have a couple takeaways that I'll just summarize our evening together. And then we will conclude. The takeaways I got were the third leading cause of death behind cancer and heart disease is medical error. Report your safety events. That's the sweet spot where there's an opportunity to correct them. Get an attorney before you answer any questions. And social media, you've been informed and warned. There's a lot of other real gems, and the information tonight so pertinent to our students and our population. And thank you both so very, very much for spending this evening with us and sharing your expertise in this very important topic. I really can't thank you enough.
Thank you.
Thank you,
Thank
everyone
you.
who's on here. Thank you for
Thank
your
you.
attention.
Wish we could have been there in person. Maybe
I
next-
know, but I think we have opportunities for other symposiums. Holy moly, my
Oh,
head's
good.
full. Thank you, students. Everyone, be well and stay safe. Have a great weekend.
Have a great weekend. Bye now.
Thank
Good night.
you.
Bye-bye.